Thank you very much, Madam Speaker. Good morning again. When I was first elected to this position, I pledged to uphold the independence of this House and to always uphold the honor of this chamber and to defend the women and men who serve here. 21 legislative days ago in January, I renewed that commitment. It is a commitment that I have tried with all that is within me to honor and respect every day for 9 years. It is a commitment which is as important to me now as it was then. And it is because of that commitment that I come to this well this morning. I ask you to indulge me for just a few minutes. There is no cutting room floor here, so I want to have a few minutes to sort of set the record straight and know that it will be a complete record. The temptation that I have found myself in is to allow the experience of the past week and a half to make one defensive, angry, and paranoid. To be attacked in the absence of any allegation of illegal, wrongful, or unethical conduct. To read news stories which tell only part of the story and which cloak opinions and erroneous conclusions as factual, even if constructed on false premises. But I choose not to be defensive, angry, or paranoid, because I believe that would be a disservice to this House and to this state. I choose instead to try to grow and learn from this moment. And I may not always like it. It may not be the easy thing to do, but I am reminded that perception is reality. I have heard through some of you from those in your districts, our districts, who have questions about what they have read, seen on television, or heard on the radio. And I want to be very candid with you. I would be concerned too if I have heard or read those things without knowing all the facts. Make no mistake, the cases that have been reported are serious and tragic situations, as are many criminal cases. I am very sensitive to that. I am also very well aware that many who proclaim themselves to be constitutionalists forget that there are specific protections in our Constitution which protect the rights of those charged even with the most vile and disgusting crimes. It's what makes us different as a nation. At issue is a provision in our law commonly referred to recently as the legislative leave. It was adopted in 1905. I was not around then. It was adopted to cover the time of the session and for 3 weeks thereafter to grant leaves to attorney members of the General Assembly from going to court and having to respond to matters in their law practice. It was amended in 2006 to include the interim between sessions. And although Ralston helped write, makes for a great headline, a quick phone call to the other members of the conference committee would have established that that was not reality. It is the same reporting which resulted in the story of a 2-year survey of cases in which legislative leave was invoked, reporting which highlighted court cases with particularly compelling and emotional components. But in a rush to create a perception, some things got left out. Number one, not all of the continuances were requested by me. Number two, not one time in all of my legal career, particularly during the period beginning in 2010, has a judge or a prosecutor in the circuits in which I practice questioned my need for legislative leave. Number three, as any defense lawyer, I have absolutely zero control over a court calendar. Now, I may have a little control here, but I have no control in the courtrooms in the mountains of North Georgia, because those are under the control of a judge and or a prosecutor. They prioritize those cases. They do. They have criteria. Some of you have heard some of that reported. People in jail that can't make bond, that are charged with felonies, are called for trial first. And you know, this trial business is not like making a reservation to be gone for a week on vacation and stay at a hotel. I practice because I choose to and have for 39 years in the rural mountains of our state. We have 3 judges in the 2 circuits that I spend most of my time. Each of those 3 judges have 2 weeks of court, criminal court, per year, because they have other obligations. So this is not something that happens like all the time, but of course that didn't get told. Over the 2 years of their study, they did not mention that 23 cases were completed, some of which by jury trial. Because you know what we do up there? I go in and meet with the judge and the prosecutor 3 or 4 times a year, and they understand my schedule, and we find times that's good for them and good for me, and we move some of these cases as best we can. More cases closed than were impacted by legislative leave. In fact, talking about these conferences, you know, there's been 4 of these cases that have gotten a lot of attention. Back in November, before this was ever a story, I met with the judge and the district attorney, and we agreed to schedule by special set trials in 2 of the 4 in either May or June this spring when this session is over. And that didn't get reported. But I am not defensive, angry, or paranoid. But an examination of all the facts causes me to reject in the strongest possible way any accusation or insinuation that I have abused or misused my position. But I come back to perception becoming a reality. And I know that a number of fair-minded Georgians have questions about the legislative leave law. And as a result, I believe I have an obligation not to dismiss their concerns, but to be mindful that the consent of the governed is a vital block in the foundation of our government. For these people, their concern for the victims in